Welcome to Brad Dacus Live. I'm Brad Dacus, president and founder of the Pacific Justice Institute. One thing that we do quite a bit of is defending religious freedom, parental rights, sanctity of life. But these free speech rights are under attack, I think, more than ever before. To talk about this and some recent litigation, we have with us here on the show with me attorney Michael Peffer, who heads up the Southern California office for the Pacific Justice Institute. Welcome to the show.
Great to be here, Brad.
Now, Michael, over the last 20 plus years, we've had a lot of different kinds of cases, but one area that is really close to my heart is dealing with the right of students to be able to share their faith.
That's right.
And we're not just talking about, college, we're also talking about elementary school level.
Yes.
I know we had one case we were dealing with where a child invited two of her friends in the 5th grade to a gathering at their church, an event at their church.
Yep.
And she gave an invitation to two of her friends, and one of the parents of one of the children objected. The girl had to write several times over and over again that she was sorry and that she will never invite anyone to church again.
Right.
That was outrageous.
That is outrageous.
And we actually had to file a lawsuit against that school district because they wouldn't change their position.
Yeah.
They finally did after we won.
Right.
Yeah. So,
right.
But these are very real, and especially as we deal with so many public school teachers. We have some teachers of faith, but so many of them are becoming more and more, I think, hostile to students and their ability to share their faith, much less not be stigmatized because they are a Christian.
Absolutely. And we see this rising hostility on campus against Christian principles, but a shrinking place where Christians can share their message, can share what they believe in. And so this always creates a problem, and we take on these cases, whether it be a student being able to share their faith at school, which they have the right to do under the law, or whether it be a professor being told they can't be Christians, they can't use the Christian ethic in teaching their class. Both things are under attack, and we get involved in these readily. And this is something that at the high school level, students have a great deal of freedom to do this, to share their faith, because they don't check their constitutional rights at the door.
That's right. In fact, there's the Equal Access Act that gives them actual protection for Christian clubs, religious clubs, from being discriminated against, and that has been very empowering.
Yes.
We have a book, Reclaim Your School, talks about students all the way up to 12th grade, what they can do to be able to live their faith, to practice their faith. And even at the college level, we have the Constitution on campus for college students, to be able to empower them, to be able to move forward, to be able to share their faith. But we've seen this go on and on. And there was a student up in Seattle. It was an interesting case. And this student, he came to Christ. He's in high school.
Yes.
And he was in the bad scene, okay? That's the long and short of it. He was in the bad group, if you will. And he came to Christ, gave his life to Christ, on fire for Jesus, which is often what happens. It's the hope for result. It's just so exciting. I mean, their lives are transformed. Their eyes are open. So he was sharing Christ, and he was sharing the gospel, passing out gospel tracts in between classes during lunchtime.
Yeah.
And they pounced on him, and they said, no, you can't do this. They suspended him once. They suspended him twice. They were going to then permanently just remove him from the school district and expel him permanently. And then he contacted us at Pacific Justice Institute. We represented him.
Yeah.
And we did so without charge. And we won in federal court that case, defending his right and ability to share his faith and not to be apologetic and not to be booted off campus.
Right. Yeah.
I think it's important. In fact, it was really interesting is when he was about to be punished the third time, or the second time, the principal opens his door to have him come in. There was another kid that was in trouble. And there our client was with the Bible open, sharing the gospel with the other kid.
Right.
Principal was furious and says, "Get in here." And he says, "Didn't I tell you, you cannot share your faith? Didn't I make it clear? You cannot talk about Jesus here on the campus, didn't
Yes.
I?" And he says, "You can have your rules, but nothing can stop me from sharing the gospel."
Yeah.
And what it reminded me of was in the New Testament when they, the people in the temple, told the apostles, says, "Didn't we tell you you can't share your faith?"
Right. Yes.
And they says, we have no choice. We have to share the gospel.
We must obey God rather than man.
Yes.
And we've seen that. I'm recalling a case where the student got disciplined for bringing his Bible to school, and they actually wrote on the discipline form, "Student will not bring Bible to school." It's just one of those classic things that you get in discovery when they're producing documents. And you look at this and you say, someone actually wrote that on a piece of paper and gave it to the student, which of course is very bad for their case, to doing things like that. And so, and this is something that we stand up for all the time. This really is a mainstay because we figure that if we have students that are brave enough and on fire enough to share the gospel, then doggone it, we want to stand behind them and let them do just that as the Lord leads their heart.
Yeah, and it's so encouraging because some of these kids are very bold. Even though the teachers are hostile, their peers are hostile because the new sexuality movement taking place in government schools, even a lot of private schools across America. So when you have these kids, though, standing up for their faith, and they're just like, "I will not deny Jesus. I will not deny what the Bible says."
Right.
And it's such a joy and privilege to be able to step in and represent them
Really
without charge, and to know that they're protected. I know we have actually in Florida, we're defending a college student who is a part of the psychology program.
Yes.
And they were booted out of the psychology program because they were a Christian. They believed what the Bible said.
Yeah.
They were going to, be competent and responsible in their counseling procedures and things like that. It wasn't like they were rogue. It was discovered that they were a Christian who actually believed what Christians believe and what the Bible says.
Amazing.
About men and people engaging in same-sex sexual acts with each other, or people changing their gender.
Yes.
So I think that this is it's very problematic, and I think we're going to see more and more cases like this as we move ahead.
Absolutely, and this is important. The schools should be the marketplace of ideas, and that includes the ideas shared by Jesus of Nazareth and who lives in the hearts of these students that want to share.
That's right, and we'll defend any of them anywhere where the American flag is flying, to make sure that their rights are protected, to make sure that they're getting the representation that they need. Now, I understand that there's a major case that was recently argued before the United States Supreme Court, dealing with this issue of the ability for students to be able to have their First Amendment rights protected, to be able to share their faith, to be able to live their faith on campus. What's going on with this case? And I think we're going to have Emily Mimna on the program.
I think we are. I think, in fact, that she's available for us right now.
Okay, great. Emily, very good. Thank you for joining us. Anyway, this is a very important case. We're talking about a student who had their First Amendment rights violated, and then it took a different turn. What happened? What are the facts of this case?
Right. The case is Uzuegbunam v. Preczewski. Many people have commented on the fact that people may not have been great at pronouncing his name a decade ago, but I think the state of Georgia will know how to pronounce his name very soon. And Georgia just can't stay out of the news. And this case has been in the works since 2006. What happened is Chike Uzuegbunam was a student at Georgia Gwinnett College, that's a state college, and he wanted to share his Christian faith. And he went out and he just wanted to hand out religious leaflets on the school plaza, and an officer stopped him and said, "You can't do this, and you have to apply for a permit to speak in a designated free speech zone, and that's the policy. So he did that. He complied with all of their rules. He actually had to hand over his literature for them to see before he did it, but he went through all of the hoops. And so he got his permit to speak in his so-called designated free speech zone, which was about the size of a piece of paper on a football field. And he went out and he wanted to hand out his leaflets and speak the gospel. And an officer stopped him again, asked for his ID, and took it back to his patrol car and said, "You can't be speaking the gospel even though you have a permit." And so he went to court. He didn't really want money damages. He wasn't looking for a payday, but he wanted a ruling that said that the Constitution had been violated and that this school's policy was in violation of his rights. While this litigation was going on, the school said, I think we should probably change this policy. So they did. And so they then turned around and said, well, since we've changed this policy, you don't have a case anymore. And so the question is, when can the government be held accountable in court for violating your constitutional rights if they just, change the policy later? So, if you sue them, they just say, oh, well, we changed the policy, so it doesn't matter anymore. And that's really what the Supreme Court was hearing.
Yeah, and interesting. You talk about moving the goalposts, Emily. Here we have first, don't you have to have a permit? I got a permit. No, you can't share the gospel. Well, then we go to litigation. Oh, we better change the rule because it looks constitutionally problematic. And we see this on college campuses. So how did this matter get to the Supreme Court?
Well, that's kind of one of the crazy things is if you look at it, you think they're arguing over $1 because that's all he sued for. He wasn't looking for a payday. He just wanted the right to share his faith and really wanted to make sure other students at his college across Georgia and across the country had the same right because that is their constitutional right. And so there are various damages you can request. As you know from the court, you can seek punitive damages, which is where you punish the party so that they don't do it again in the future. You can seek compensatory damages where you're compensated for your harm. If you're in a car accident, they pay for your car, they pay for your medical bills, etc. Those are usually the damages we're most familiar with. You can ask for declaratory relief where the court declares that your rights have been violated. And you could ask for nominal damages, which is where they say, we're going to give you an amount of money. It's not a lot. Usually it's $1, $10, but it's something because the harm that you suffered isn't something that's easily calculable. Now, if you get compensated, get compensatory damages, you have to, plead specific facts and make a specific showing. My car was these are my medical bills. When something like free speech is violated, how do you put a price tag on that? Right. And so what the state's saying, well, you can't put a price tag on it, so don't sue us. And the 11th Circuit bought that argument and really, frankly, went rogue from all the other circuits, which is what we heard from the justices on the court today, saying the 11th Circuit clearly is out on its own here. And that's really what we're asking about today.
So this nominal damages, and it's something that we deal with all the time in constitutional cases where we are suing for a government action. It's a way to say, look, the courts recognize that this person was damaged simply because they got violated, their speech got violated, or in this case, but other case constitutional harms as well. And so it also implicates attorney's fees, correct?
That's right. You need to be a prevailing party. And so sometimes the only claim that you're going to win on or damages you're going to receive are these nominal damages. And of course, the American system does not award attorney's fees automatically. You have to prevail in court. And then even then, usually damages, attorney's fees are not really the same amount that was actually expended by your attorneys, but it's something. And that's important. It's not, you think, well, wait a minute, is this just trial attorneys trying to line their pockets with frivolous lawsuits? And it's not that. It's if you're not going to have attorney's fees paid after the fact, if you do have a valid claim and your constitutional rights were violated, who's going to take these cases? You have pro bono law firms, of course, like PJI, but there are a lot of rights being violated and claims that need to be brought. So if no one's going to bring these cases, basically the government can run unchecked because, litigation is very costly. It's very time consuming. This case, goes back to 2006. So, if you don't have some type of check on these infringements and violations of constitutional rights, nothing's going to change.
Right. Well, Emily, you actually heard the oral argument that took place before the Supreme Court. What was your takeaway? What are we looking at as far as the leanings of some justices versus others after hearing oral argument?
My takeaway was that I was very grateful I was not having to defend the state's actions. The questions for the state's attorney were very harsh, and I think that's fair to say. I think they were clearly leaning towards the plaintiff, Chike. And just to give a quick run through, Justice Kavanaugh said, looking at the common law, tradition, history, our court's own rulings, the other circuit court's rulings, nothing here is weighing in your favor. And then you can run through the most liberal justices, and nothing there was helpful either. Sotomayor said, your arguments don't really make sense based on our prior holdings. Justice Breyer really took him to task and said, what it sounds like Georgia did here was say, you, young student, you can't pray here. And that's a violation. Now, because you can't put a dollar amount on that doesn't matter. And then really the big, I think the hammer really dropped with Justice Kagan, and she brought up an example that was later picked up by Amy Coney Barrett. And what Kagan brought up, believe it or not, was the Taylor Swift case. And Justice Kagan said, arguably the most recent famous case that people know about involving nominal damages is the Taylor Swift case, where she brought a lawsuit against a record producer who sexually assaulted her. And Taylor Swift said, look, I don't need money, I don't want money, but this happened, it was wrong, and I want my day in court. And Justice Kagan said, we all know that sexual assault, that the harm done is a lot more than $1. So because Taylor Swift only asked for $1, her case doesn't count. And that really, I think, was not something that the attorney was expecting, and something that every justice after that question, after Justice Kagan brought this up, latched onto. And I think it really brought the point home, which is just because a harm doesn't have an obvious dollar amount doesn't mean it's not a harm. Yeah. And I really liked the response that plaintiff's attorney gave, which is that it's not that the $1 isn't a lot, it's that the harm is quite a lot.
Yes, yes. Now, Emily, did we happen to hear anything from Justice Thomas this time? Because he rarely asks questions.
That's a wonderful question. And yes, we did. One of the interesting consequences of course, the Supreme Court is now online. So they're hearing cases by teleconference. And so they've changed the format. Normally, when they're hearing cases in person, you'll have justices interrupting each other, and they're talking to each other with the questions, and we still have that. But now the format is 2 minutes for justice to ask questions and to have the answer, so it's pretty rapid fire. And so Justice Thomas has his allotted time, and he uses it. And for those who haven't heard him speak from the bench, it is very powerful. And he sounds just like James Earl Jones, and he could just read you the phone book, and you would lean in and listen. And he also was involved, and it was really great, because you do see every justice having their allotted time and asking questions, and you kind of move down the line, and they feed off of each other, of course. And like I said, with the Taylor Swift example, once that kind of entered the courtroom or entered the airwaves, the justices were really interested in that point.
Yeah, so this call, we've talked about the dollar and the nominal damages and what that means. What's actually at stake in this case?
Well, quite a bit. Obviously, we're dealing with the suppression of free speech, the suppression of religion. We're seeing that, of course, now on unprecedented levels with COVID restrictions and governments, local governments trying to respond and really overstepping time and again. We're also looking at universities, where we're seeing universities really take biased and usually liberal stances, where we're going to allow this speech but not that speech. We don't like this message, we do like that message, so we're going to make you jump through all these hoops, comply with letting us see your literature, let us know what you're going to be passing out. We're going to give you the permit, and then we're still going to say you can hand out literature, but you have to stand there like a mime. We're not going to let you speak. And so it's really important to be calling universities and pushing back when they really are violating their students' constitutional rights. You know, universities are supposed to be places for debate, the discussion and advancement of ideas where we're shaping future leaders. And to have this chilling effect, and I should say that there was another student who also wanted to share his faith, and he was also part of this lawsuit. His name was Joseph Bradford, and he didn't. He stayed quiet because his fellow student was threatened with disciplinary action.
Wow.
You know, he was harassed by the cops in front of the entire student body.
Right.
And so this chilling effect is very real.
And that's what we have to stop. That's why this case is so important. We have to stop this constant tyranny. Emily, thank you so much for reporting on this interesting and important case. Really appreciate it.
Thank you, Emily. Thank you very much. Take care. Appreciate it. You know, Michael, I think this is a classic reason why we're opening so many offices across the country.
Yes, it is.
Because free speech is under attack. You know, we've got offices right now in Miami and New York, Mississippi, Texas, Colorado, Nevada, Washington State, Oregon, California.
Yes.
We're now looking at some other places like Chicago, Detroit, Cleveland, Philadelphia, Baltimore, Boston, to name a few, because of this tremendous assault on religious freedom, on free speech. It's becoming more and more exaggerated on campuses, on public places, people being criminally prosecuted, pastors for publicly preaching the gospel.
Yes.
So we're going to be watching this case. I'm optimistic, especially based on what Emily
It
said.
sure sounds like
that
it.
we're going to see some good results.
We may even see a unanimous decision here Saturday.
And it's rare because with Sotomayor, of course, she's sort of isolated. She doesn't have Ginsburg in her corner anymore.
Yes, that's right.
So maybe she's just going to, side with the others. But that would be nice to have a 9-0 on such a very, very important case.
Absolutely.
That's something that we're watching and impacting our cases as well.
Absolutely.
Now, we've got a situation growing in terms of speech dealing with the social media and social media platforms. My understanding is that the conservative social media platform Parler is the latest victim of big tech's purging and sweeping of such institutions, conservative institutions of thought, the shutdowns on the social media. This is a serious concern, and because Parler was picking up lots of people leaving Twitter and Facebook saying, we're tired of this perceived tyranny, we want to go somewhere else. What's the latest on this, and is Parler going to come back again, or have they been snuffed out completely by the state of big tech?
That's right. Well, the thing is Parler was, of course, as you said, it was an option for conservatives that wanted to speak and didn't want to be shadowed or corrected or all the nonsense that both Facebook and Twitter pose. And so it became popular. In fact, Pacific Justice Institute had a Parler account as well. And now, recently, Parler has been literally shut down by Amazon, and then its app cannot be accessed on Apple or Google. So they have filed suit, and we'll have to see what happens. Yesterday they filed suit in this matter, and it really must be taken care of. We cannot afford to have big tech have the right to basically shut down everything.
Shut down
everything
speech.
They don't like.
Yeah, any speech they don't like.
Yes.
It's worse than, it's like a private sector communist China.
Yes.
And it's tyrannical. And that's one reason why I encourage people if they want to make sure they're still going to continue to get information.
Yes.
Hischannel.com, this is a great place to go.
That's right.
Also, they can sign up to get our Legal Insider.
Right.
They just go to pji.org. It's once a week. It's a short Legal Insider update. This is information already that mainline media is not covering.
Right.
But if they continue the shutdown, and I've heard pastors talking and who are on the internet, ministries, and others who are being shut down as we speak.
Yeah.
In a purge that I never thought I would see in my lifetime.
Unbelievable.
It's very concerning, simply because of thoughts and ideas I think that's very concerning. So I encourage you out to, if you want to keep up with what we're doing, no matter what happens, no matter what takes place, go to our website, pji.org, and download the Legal Insider. The Legal Insider. We'd love to keep you updated.
That's right.
It's very important as we all work together to fight for our freedoms and liberties as things progress.
And we simply cannot let this stand. It's time to speak up. It's time for all of us to speak up. And I don't know ultimately what this is going to mean, but I think it's a fight that we need to have. And perhaps Congress perhaps might do something about this because of Section 230, although right now the party in power seems to like this kind of censorship because it doesn't fall against them. But nobody can be safe if the government can simply say if these private entities who occupy more and more of a part of our life can start saying, hey, we don't like your speech, we don't like what you do, so we're not going to allow you to monetize your information. All that is basically going to be a very detrimental, chilling effect on free speech, and we just can't stand for that.
No, we definitely can't. It's very concerning that right now big tech has it both ways. They have the ability to edit and censor, and at the same time have complete immunity.
That's right. Yeah, exactly.
From what they do and how they treat their customers or treat people wanting to express themselves. They historically, you can't have it both ways. You're either providing a free speech platform where you have immunity, or you're an editor, you're engaging editing and publishing, those kinds of things, in which case you don't have immunity and you can be subject to the actions that you take. So I think that's what we need. Also, I see this as classic antitrust. Teddy Roosevelt would be rolling over in his grave right now to realize, I mean, this is the nightmare. This is the 1984 book, if you will, where you had this kind of control of speech and thought, and people are fearful of losing their jobs, losing their ability to express themselves, being targeted, attacked. It's very, very concerning. And I know people close to me, I know people with ministries that have been impacted, and they cannot proclaim the gospel anymore in some of these platforms because they're being shut down. And
that's right.
So we need to unite together to stand together for this protection, and I'm hoping at the end of the day that this will be corrected. It definitely needs to be corrected. Yeah,
no matter what your political ideology is, this can't stand.
No,
that's
right.
Right now we have become a digital age. We have become an online culture, for good or for bad. That's how we communicate ideas, and that's something that has to be dealt with and has to be stopped.
Yes, definitely. Well, when we return, we're going to talk about a matter involving the pro-life movement and a positive action that a governor took to respond to the cries of the unborn. We return right after this.
We direct a statewide order for people to stay at home. That directive goes into force and effect this evening.
Okay, everyone, welcome to this Pacific Justice Institute Zoom call addressing challenges to religious freedom, and specifically the ability for churches to gather.
Pastor John Duncan says his Sunday sermons won't stop inside his house of worship. Officers entered his church service last Sunday, explaining the orders to close.
Recently, your church decided that you wanted to have a parking lot service, and yet the state of Washington said no.
We were contacted Thursday afternoon by a representative from the governor's office, and they told us it was no longer allowed. So we contacted all of you, and your staff and your lawyers were just so helpful to help us craft a response to that.
For the second day in a row, Oregon Governor Kate Brown faced legal challenges over the state's coronavirus restrictions.
We challenged Governor Brown's orders. We argued that her orders are no longer in effect because she failed to follow a certain part of the Constitution.
My wife and I have been leading Bible studies in our homes for the last few years. And then for the last 2 weeks, the Attorney General and our Governor Inslee argued with 156 pages and 4 separate court documents saying that we did not have the right to pray and have Bible study in my front yard.
Where do we go from here? I get calls at the Pacific Justice Institute all the time from pastors, ministers, and people saying, okay, where are we? Where do we go from here? This can't go on forever, can it? Can the government permanently keep churches from meeting?
I've represented roughly 14 churches, 2 other religious entities, and at least 40 individuals from all across the state in a suit I filed against Governor Brown in Eastern Oregon.
So that judge that you appeared before, that ruling made her executive order null and void and liberated everyone in the state of Oregon. I mean, churches, businesses.
Hello, my name is Pastor Ken Peters, and I am the founder and lead pastor for the church at Planned Parenthood. We are boldly against abortion. We feel like it is the murder of human life. Well, when we got the lawsuit from Planned Parenthood, I'm a pastor. We have never been in a lawsuit before in my 22 years. I made a few phone calls, and over time I ended up with the Pacific Justice Institute. Glory to God. We thank Jesus with all of our heart for the Pacific Justice Institute. God is so good to put them in our state, in our area, and in our path. And we are so thankful that we can covenant together.
A Walnut Church throwing caution to the wind and hosting an outdoor family event today, despite reported threats from LA County officials to shut it down. Lawyers representing On a Mission Church say the church is being discriminated against and targeted by LA County simply because it is a religious institution.
The fact that the county has explicitly and blatantly allowed for other outdoor gatherings with a different perspective, a leftist perspective, a non-Christian perspective, shows the blatant bigotry, and that's why this and actions like this are unconstitutional and will in the end not hold up in a court of law.
Pacific Justice Institute took our case without us having to put up any type of funds, and when Pacific Justice reached out to me and they took our case, it was amazing, because again, it would have been huge. Right now, probably the church would have been out of pocket.
Welcome back to Brad Dacus Live. We've noticed recently some attacks on the pro-life movement in some states, and there was one state in particular, I believe Massachusetts,
Yes.
that had a real battle on its hands in terms of legislation that was going to empower the pro-abortion machine even more. What happened?
Yeah, so here we have, we're hearing from Myrna Maloney Flynn, who's the Massachusetts Citizens for Life. She told the Pro-Life Weekly that it has been 2 strenuous years after the legislation was filed, but the public has responded positively, and she said, to the pro-life group's efforts to educate on the abortion issue. And so what these folks did is they took the fight, not violence, they took the fight to the pro-abortion crowd and said that, look, this bill cannot stand. And the initial version of the bill would have allowed girls of any age, to walk into an abortion clinic and obtain an abortion.
Okay, whoa. So let's say there's a 12-year-old girl. She's pregnant. She walks in without parental notice or consent. She has an abortion. I mean, what if the girl had been attacked? What if she'd been raped? I mean, we're looking at statutory rape right there on the face of it.
Yes.
And yet these thugs at Planned Parenthood and these abortion clinics have a reputation of not contacting not only the parents, not contacting the police.
That's right.
But letting these thugs go off while they make their money killing the unborn baby.
Yeah.
That's what they wanted. The abortion industry obviously wanted this because that means more people will come to them, have abortions without parents working and helping their child mentally, emotionally, and go through the alternatives.
Yeah, the baby killing industry will stop at nothing. It doesn't matter. It doesn't matter how damaging this can be. Can you imagine a 12-year-old daughter and allowing her to go through the immensely damaging a procedure of abortion, and it is without question damaging to the psyche at the least, the body also, but in other ways, emotions. This is a very significant procedure, and they want to take a 12-year-old or even whatever age is the youngest they could give birth or become pregnant. And this is why it needs to be dealt with. So thankful for this Massachusetts Citizens for Life, and we know that the governor there, Charlie Baker, who happens to be a Republican, he vetoed the legislation, and that helped out to some degree. It didn't take care of. The bill is still there, but it only helped out to stop the age being just indiscriminate.
Yeah, well, I think that's an important part of the legislation. That's, the struggle for defending the unborn is paralleled with parental rights.
Yes.
And the ability for parents to work with their minor children. They're called minors for a reason.
That's right.
I mean, these are major, huge decisions.
Yes.
They have to have parental consent to go into an R-rated movie. They should be able to, or PG-13 if the child's just 12.
Yeah.
There's so much parental consent in our society. Something so monumental and life-changing as a young person killing an unborn child inside them without parents knowing about it, being able to be a part of it is horrific. I understand many states across the country have adopted legislation requiring minors to have parental consent, and that is constitutional, isn't it?
Yes, it is constitutional. The courts have held largely that you can have these legislation as long as there's a way out. So a court can they can go to court and say, if I tell my parents I might be abused or whatever, and the court can be the relief valve, but it's perfectly acceptable as long as there is that relief valve there of a court to have limits on this. And I actually think that's too much, but I'll accept that. In a sea of bad choices, I'll accept the less bad choice and be able to regulate for young people. This is so damaging. I mean, just the fact that the changes that undergo a woman's body when she's pregnant, I can't imagine a minor going through that all by herself without the love of her parents.
So it looks like the legislation is now, instead of being any age, it's going to be at 16.
Yes.
I think it should be 18. Actually, I think abortion should be illegal.
Yes.
But nonetheless, so they can go down at the age of 16. Under 16, they've got to go into court.
Yes.
And the presumption there is that only a child who really is resolved on, number one, having an abortion, and number two, that their life is really going to be in danger,
right,
will go through all the hoops to actually go into court to get that protection. I think even then, I think the majority of those cases are going to be cases where the child just doesn't want to face their parents. The parents aren't going to kill their child.
Right.
It's just the shame or the disagreement or something that the child's trying to go through. And that's something people are going to need to watch moving forward, definitely.
Yeah.
But hats off to that governor, Governor Charlie Baker.
Yep.
I didn't know that he was going to do that. He's not a real conservative governor. He's of course governor of Massachusetts.
Yes.
But yet hats off to him for doing that. I think that was fantastic.
Indeed. And hats off to the people that are pro-life in that state that stood up and said, no, we don't want this. That helps a lot. It does help a lot when the people start to say, you know what, this isn't good. We don't want to accept this. And here it actually did something.
Yes. Now, Pelosi, who is not pro-life,
by any means.
By any means. She is one of the biggest fans of baby killing, probably in Congress,
Yes.
without question. She's a real proponent of killing unborn babies,
Yep.
all the way up to the 9th month,
That's right.
as far as legally speaking. So it was interesting that she was in a position to welcome 45 pro-lifers to the 117th Congress. Tell me more.
in what has to be just the amazing ironies of the year here, our young year, is that Pelosi had to welcome and swear in the new congressional leaders, now lawmakers, that were recently voted, and 45 of them are pro-life people. And this Carol Tobias, who leads the National Right to Life community, says there's an excitement because rookie lawmakers who are proudly pro-life, a number at least 45 in the House. And she says the unborn babies are going to have even more voices speaking up for them in the House of Representatives this year. So for all the political disappointment, which there is political disappointment, we recognize, but for all the political disappointment, there is really some encouragement that we have 45 new pro-life lawmakers in the House of Representatives.
Now, some from the left, when hearing this, will say, well, they're probably all men. It's probably 45 conservative, cold-hearted, uncaring for women men. Okay,
Yes.
that's what they're likely going to think. But reality, 27 were pro-life male freshmen. 18 were pro-life female
Yes.
freshmen.
Yes.
And all of them were Republicans.
Yes.
So an interesting takeaway is that women are having more and more of a participation in Congress, but specifically, we're seeing more pro-life women serving in Congress. Yes. This last election, it was a major shift in that regard in a very positive way, with pro-life women defeating incumbents in the primaries who are not pro-life or strong pro-life, and also in the general election.
Absolutely. And you know, we cannot underscore this enough as the importance, because look, the bottom line is the pro-life baby killing, the pro-abortion baby killing industry, Planned Parenthood et al., are in this for the long haul, and they want to keep their steady stream of income that all they need to do is kill babies to get. And we can't allow that. And so we're seeing a much more vibrant Republican Party as to pro-life, and there's lots of reasons for that. But at this point, for our purposes, it's good to know that the pro-life cause is alive and well in the Republican Party, and we have 45 pro-life legislators to thank because of that.
Yeah, it's so encouraging on the legislative side to see that. Now, on the litigation side, I know we've had a number of cases addressing the pro-life issue. One was dealing with a law in California where they were requiring all pro-life clinics
That's right.
to have to post a large sign telling women in the waiting room of a pro-life clinic where they can get a free or low-cost abortion.
That's right. Yes.
And we were the first to file a lawsuit to challenge that. It went all the way to the Supreme Court. Supreme Court took up one of the other cases for oral argument, but they took up all our cases, went up there, and the Supreme Court ruled that that was unconstitutional.
That's right.
To compel a pro-life clinic to have to advertise for the abortion industry. I mean, it's sort of a no-brainer.
You would think, wouldn't you?
You know, but but the Attorney General of California at the time, they're looks like they're going to have a very important position in Washington, D.C.
Right.
In the next administration. So we'll have to watch to see what is brewing in the cauldron.
Yes.
To challenge the pro-life movement moving forward. But I'm very positive about that case and other pro-life clinics that we've defended, where they were told they couldn't build somewhere, they couldn't be in a community, and we step in, and at the end of the day, they're occupying,
That's right.
they're serving that community, and we love to do that, always without charge, of course. We always love to serve the pro-life movement. In fact, Michael, whenever I'm invited to speak at a fundraiser, and it's oftentimes they'll offer you an honorarium, and it goes always goes to Pacific Justice Institute. That's our rule. But that whenever it's a pro-life clinic fundraiser that I'm speaking at, I will refuse any honorarium to myself or PJI.
Yeah.
Because we are so dedicated to do everything we can to further what they're doing to help save women and unborn babies from the atrocities of abortion.
Yeah, and that, I'll tell you, you bring up a great point on this issue of judicial occurrences. We've had some fairly good judicial cases that brought forth pro-life principles, and this is one of them, that you can't compel this pro-life clinic to speak on behalf of abortionists. And that's how crazy it's gotten, is that they will go that far as to force a pro-life clinic to be a proponent of abortion. And the Supreme Court said absolutely not to that, and it's stronger because of it. And we just talked about what happened in Massachusetts, and we've seen other cases similar to it where some restrictions are finally getting to see the light of day. And as far as I'm concerned, you can't have too many restrictions on this barbaric practice that somehow has become the law of the land in the United States of America and many places of the world.
Yeah, well, I know we also have a case in the Northwest dealing with a group of Christians, and they're not engaged in violence. You know, we're completely unopposed to any and all violence of any kind, anywhere, period.
Yes.
So, right up front, we're talking here about Christians having an outdoor church service in front of a Planned Parenthood abortion clinic, and they're being sued by Planned Parenthood even though these people are in a traditional public forum. They're not on private property.
That's right.
It's grass area owned by the city. It's a traditional public forum, your protected speech zone. And they're being sued because Planned Parenthood is alleging that they're losing business, i.e. they're not killing as many unborn babies probably.
That's right, yeah.
So I think that that's a very important case that we're handling.
Yes.
And I'm hopeful that it's going to turn out advantageous, especially with this Supreme Court that we're dealing with. I think they understand free speech pretty well.
I think so too, and then that is an important case in Washington. The church tried to get along. They agreed to some limitations as to what time they would be there and what time they'd start, but that was not enough for Planned Parenthood. And so this, I think it's called the Church at Planned Parenthood, which is an ironic name for a church. And but we're going to keep pressing forward on that and other cases like it.
In fact, there's an interesting case that the Supreme Court has denied review over that I'm really concerned about.
Yeah.
And it's Bruni versus City of Pittsburgh. And we're dealing with the censorship zone law. What's going on here? There's some people out there near an abortion clinic wanting to share their faith. What's the problem?
Yeah, so, as we've talked about and inferred even right now, the courts have, for time immemorial, the courts have allowed for the public sidewalks and streets and public parks, things of that nature, to be free speech zones, basically. Public forums, we call them. But what has happened here is that many cities have allowed for rules that restrict where pro-life persons can share their faith, can share what help for the person seeking an abortion. And in Pennsylvania here, in Pittsburgh, they have a buffer zone. So they paint a zone that you can have this speech, but you can't in this painted zone that they establish, which happens only at 2 abortion clinics, lo and behold. And so there the folks were attempting to share their faith in this spot, and the city came down on them. They went to court, and it made it up to the Third Circuit. And there, the Third Circuit said something that it's kind of like we said, in a sea of bad choices, at least some little good result is good. And here, what was good about the Third Circuit's ruling was that it doesn't apply to sidewalk counseling. So if somebody is wanting to sidewalk counsel, that is, share their faith on the sidewalk or whatever, they can do that, but you can't hold signs, you can't scream the Bible or anything of that nature, and that's unfortunate.
Yeah. Well, now let me just give you a hypothetical. So, let's say I'm out there and I'm preaching the gospel. I'm preaching. They're saying that I cannot preach the gospel, even though it's a public sidewalk, a public area. I can't preach the gospel because it's a part of this bubble zone. Yeah. That it may cost Planned Parenthood some business or something.
Yeah, I think that the wording that was used was you cannot do, quote, patrolling, picketing, or demonstrating. And so I think that if you were wise, you could do sidewalk counseling, which often carries with it the name of the Lord and the promise of blessings from the Father, things of that nature. And I think that's going to be acceptable. But the court is very wary about this. And unfortunately, the nature of this story is that the Supreme Court declined to hear it, which is not a good thing. We really would have hoped to get a little bit more out of the Supreme Court on a case of this importance.
Yeah. Maybe they're looking for something a little more decisive.
Yes.
Sometimes they won't take up a case because they're like, the facts of this case aren't really clear cut.
Yeah.
Let's wait for another case that's better, more clear cut. I just don't see this Supreme Court with the 5 justices upholding this kind of a limitation on speech. Yeah. Obviously, violence, yes, that's not protected.
Of course.
Harassing people, calling them names, I get that.
Yes.
But preventing people from being able to share from their heart, a heart of love and compassion and conviction to individuals other than just on a conversational level, but actually be able to proclaim.
Yes.
I think that's really concerning. So we're going to be watching that. We have a number of case matters. I know that I've taken on in the past, several in Texas.
Right.
Where actually one was in, just in several cases. I know in Dallas in particular, there's one I'm thinking of, where they wanted to be able to preach and proclaim the gospel. It was near Planned Parenthood, and we had to take that to task to defend their rights.
Right.
Because of the extreme hostility that the Dallas Police Department played against this person as a part of a church ministry to preach the gospel. And when Planned Parenthood complained, it became very nasty. So it doesn't really matter where people are located. It could be in Texas. It could be anywhere.
That's right.
We need to defend those rights and not assume that just because they're in a state that's presumably a conservative or pro-faith state doesn't mean the city, much less the downtown area, is going to be pro-faith or tolerant towards people of faith.
Not at all. In fact, we've seen this kind of harassment in many jurisdictions that others may have thought were conservative.
Now, speaking of harassment, my understanding is that there's an exemption, a ministerial exemption, as applied to different discrimination provisions. But apparently there's a case involving a Catholic university that was sued under Title IX, claiming sexual orientation discrimination. And the question, I guess, in this case was whether or not the ministerial exemption applies. Give us some background on this case so people understand what we're talking about.
Yes. So this person had a position, and they were the assistant director for music and worship, and they were. I believe she was a lesbian, and so she felt that she was being harassed over her sexual orientation at the school, at this Catholic university. And so the school stood behind what they were doing, and the person was brought this hostile work environment claim. So remember, there's wrongful termination claims when the person's been fired, but there's also hostile work environment when perhaps they're not fired, but it's just they feel like they've been harassed, and you you have this doctrine called the ministerial exception, and in that under that doctrine, churches and church entities can hire and fire the ministers of their choosing, and cannot be held liable for these kind of employment actions. And in this case, the court ruled that this person was a ministerial employee, and because they were the head of the music and worship, and therefore it cannot be held them liable.
Yeah, head of music and worship. That sounds pretty ministry to me.
Yes, yes.
I mean, she was clearly had a ministry position.
Yes.
For a Catholic university, and I'm assuming it's a Catholic university that follows the teachings of the Catholic Church. Some of them have gone liberal and rogue and open defiance against the traditional teachings of the Church, which is another topic. But so, assuming that they are true to their Catholic faith, Catholic beliefs, I can see completely why they would not want to have someone in a ministerial position who, not just had an orientation, but I'm willing to bet, because the Catholic Church does not have a position of firing people just because they're tempted for sin or just because they have the possibility of sinning some way. The sin comes into an attitude of saying, this is a good behavior when the Bible says it's not.
Yes.
Or this is, whether or not there was a relationship she was having at the time, I don't know.
Yeah.
But I know that the Catholic university or any Christian or any kind of traditional university like this would not want to fire someone who, with a biblical worldview, said, this is an area I'm struggling with, this is an orientation that I have that I'm struggling with. I'm sure that there was more to it than that in terms of the attitude. It was probably a butting heads of theology and moral acceptance or and conviction. So I think they were well justified probably in this, and I'm glad that the court decided to rule the way they did. It's if they ruled differently, this could have affected churches.
It can.
Private Christian schools.
Yeah, we cannot overemphasize the importance of the ministerial exception. Really, the ministerial exception basically says a church can hire and fire its ministers at will for any reason or no reason. The church can do so. That's the law. The law allows churches to choose their ministers. And the reason why is clear here. Here you have someone who has an alternative lifestyle that is alternative to the church's basic teachings, and they are in a leadership position that is music and worship, which has been held throughout the country as ministerial positions. So we want the ministerial exception to be interpreted as broadly as possible, and so that we can have protection for churches to hire their ministers. If they're doing the wrong thing, that can be dealt with another way, and it usually is within church discipline. But we need churches to be able to hire ministers and fire ministers if they don't comport with the biblical requirements to be a minister.
Yeah, and once again, we don't know the details of what the plaintiff was doing or involved in, but we do know that based on the Catholic Church's track record, that they wouldn't have just fired her, presumably just because she said this is something she's struggling with, if that was her heart and attitude.
Yeah.
That's I think a real important distinction. And then if we were talking about, let's say she wasn't in a ministry. Let's say she was a janitor or a secretary doing secular work.
Yes.
And she was engaging in a lifestyle that went against the teachings of the church. But she's not in ministry.
Yes.
Could a religious institution, whether it's a church, a school, a Christian university, be in a position to release someone, fire someone who is openly and defiantly engaging in a lifestyle against the teachings of that religious institution, even though it's a secular position?
Yeah. So
and what should they do? What should a church like that do preemptively?
Yeah, so first of all, preemptively, churches should be able to have to say, hey, you need to sign a contract and/or not an employment contract, but an agreement that you will profess the doctrine and follow the doctrine of the church, and we can always help with that kind of a thing. But in our situation here, what we need to do is, the further away from the minister that person is in their employment, the less protections there are for the church, although there are still protections.
Yeah, and I know that we make that available for churches and ministries all across the country, and help them with that kind of an agreement to uphold moral standards and beliefs of that institution.
Yeah,
and that can be used and to be given to make sure all employees are in agreement with it. It makes sense if you've got an institution. Their purpose is to practice a faith.
Yes.
You want that institution to be true to its faith, and along with that, the employees. To me, it just makes sense. But we're going to see some more attacks in the coming year, I'm sure. Next 2 years in particular, we'll be addressing this again, I'm sure. So, folks, there you have it. It's our God-given freedoms we're talking about. Now, let's choose to keep them. I'm Brian Dacus, president of the Pacific Justice Institute. Let's continue the fight for your freedoms.